Good evening, everyone. Today, the Supreme Court of the United States released a number of decisions. Perhaps the most newsworthy one, notable, is, Trump versus CASA, Inc., that has to do with the authority of district courts to issue broad, nationwide injunctions. And what the Supreme Court decided on a 5-3 basis, when it's 5-3, you know who the three are going to be. Okay? It's going to be Jackson, it's going to be Kagan, it's going to be Sotomayor. All right? Decided that these nationwide broad injunctions, you gotta have some standards to them, and they're just being tossed out a little too frequently. Goddamn mosquito. The Trump administration in this case, I thought, the lawyers actually had quite a strategy to it. See, it has to do with an order that the Trump administration had that said that it's denying the birthright citizenship that, it seems to my reading, is guaranteed under the 14th Amendment of the Constitution. If you'll look at a prior video that I did, I talked about these nationwide injunctions. Now, the way these things work, okay, you've got somebody who is doing something, an executive, a member of the government, who is doing something that affects people broadly, okay? And you say, well, this is unconstitutional, and should there be a way to stop it? From a purely political philosophy standpoint, I look at it and I say, yeah. You know, if let's say Obama decided that he was going to, well, as I call him, Droney McPeace Prize, decided that he was going to target Americans with drone strikes back in 2016. Let's say he was going to go to, the panhandle of Florida and target Tallahassee and say, we're going to make drone strikes over here in order to get back at voters. You would look at it and you would say, you would hope that a court would be able to say, look, these drone strikes, these are assassinations, extrajudicial killings, executions of Americans without the right to due process. You would hope that a court would put a stop to that. Note, he actually did assassinate with a drone strike in foreign territory an American citizen under the age of 18. So it's, I'm taking something a little bit reductio ad absurdum, but there is something to take this reductio. Something that was absurd as it was to begin. But you would think that a court should be able to go ahead and say, no, we're not going to do any more of these extrajudicial killings. And you can do that. I can see that point. With that, there is irreparable harm. Once you kill a person, that person is unable to go to court to seek redress, to say, court, this was bad. I shouldn't have been killed. Can you please go ahead and, as a matter of law, reverse this for me? I can see that. But from a constitutional standpoint, one thing that irritates me about what happens with politics today, is, we have available to us the interwebs. Whereas before, 20 years ago, maybe 30 years ago, one would have had to go to a law library in order to access these rulings. But now you just go to supremecourt.gov, go to the opinions, and they are available to all of us. We can all see these things. We can read them. We can take a look at what these justices are actually saying. But people don't want to do that. People want to take a look at what the outcome is and say, oh, I don't like this outcome, therefore this is bad, this is evil, this is horrible, this is terrible. No! For the time being, this is something that's going on the left. That pisses me off because they're ignorant and they aren't going to bother to educate themselves. Of course, it's the same shit that we saw during COVID, which is, we had the medical literature that was actually available to us. And those of us that decided to go ahead and read that literature ourselves, that we could take a look. Hey, look, there's NCBI, there's PubMed. There was the Journal of the American Medical Association, the New England Journal of Medicine. There were these studies that were put out there for all of us to be able to go ahead and look at ourselves. And what were we told by the douchebag authoritarian, just freaking anti-science, anti-education, anti-everything? Oh, you did your own research. As if we are unqualified to go ahead and read these things ourselves. And the thing about it was, they didn't read them themselves. Well, we can. You are smart enough to be able to read these things yourselves. You could take a look at a Supreme Court opinion and you can read this thing and find out what is going on with it. It's not that hard. It might take you a half an hour to do it. But you can take a look at the words that were actually used by these people. Now, when you're reading these opinions, I think one of the smartest things to do with this stuff, the way I do it, I like to read the dissents first. Because the dissents, I want to find out what it is that they are having to say with this thing and see whether or not the majority opinion actually got this thing right with the points that it raised. And look, on this one, the majority absolutely freaking nailed it. Not from something that I agree upon politically, but from something that you look at and legally and say, yeah, they got it. The majority said, look, there is a right to redress these things. If this thing is inappropriate and if this thing is improper, everybody has the opportunity to go to court, go ahead and say, hey, I'm going to sue the court. I'm going to seek redress for this. They all have the right to this. They can do it. And what these nationwide broad injunctions were doing was that they were taking people who were not litigants. They were not named as parties in these suits. And it said, we are going to involve people who did not consent to this jurisdiction to begin with. What is a person supposed to do if a court says, no, you're involved in this thing? Does that person have the right to redress to say, hey, wait a second? And regardless as to whether or not they would actually do it, there are people out there, and it's happened in history, people who have faced execution, who have said, quit making these appeals. I deserve to die. I want to die. Let's get this thing over with. Regardless of whether or not you agree with them, they have that right to speak for themselves on this. And in a lawsuit, you don't want to involve people inside of a lawsuit who have not consented to jurisdiction of it or have not been actually served as defendants themselves. It's fundamental. The dissent, the main one by Sotomayor, it raised some very good political points, but from a legal standpoint, it just didn't get it. And then Justice Jackson, her dissent, oh my freaking God. it was a fantastic political, not legal, political. It raised these political questions. It brought these things up that were matters of politics. It was a manifesto. And if you look at, I looked at this, and when reading this thing, I looked at Justice Coney Barrett's opinion, and she actually raised the issue with it about Justice Jackson's dissent, and said something to the effect of, we're not even going to dignify this thing with a response, except to say that, and it was 100% correct on this, except to say that the fears of an imperial, I don't think imperial was the word, might have been, imperial executive branch have been replaced in hers by the threat of an imperial judiciary who answers to nobody. I think they got it right. My key point on this is to say, all these people commenting on this decision, 99% of them have not read it. 99% of them have not read a page of it, have not read. What they do is they look at it and somebody says, oh, this decision was made. How about this? Oh, how would you feel if you were this? It's not about feelings, dog. This is unfeeling. This is not about political questions. This is about what the law says. And the law, the tradition, this is something that's come from the Enlightenment all the way down to the Magna fucking Carta. Says that if judge is going to order you to do something, you better be a party to this thing. And in the event that somebody wants to look at this and say, well, hey, this is something that affects everybody. Well, no, wait a second. I have not been given notice and the opportunity to respond to this thing. And yet here's an order that affects me. How the heck do I come into this thing and say, I don't want to be a part of this? There are the opportunities of joinder that under the Federal Rules of Civil Procedure, you can go ahead and join in, you can intervene, you can object to it, but that's not the point. The point is there are these people who have not been involved, who have not had anything. It's in effect an advisory opinion to say, oh, anybody here who does this, get that. There are class actions, there are representative actions, there are ways to go about this thing. And this decision, while I am libertarian to the core and I have a huge goddamn problem with the result, from a process standpoint, it freaking nailed it. I don't ever like looking at things and saying, hey, they got it right. But, I'm also a Raiders fan. And it's been pretty gosh darn difficult for the last 25 years to be a Raiders fan. But when they're losing, they're losing fair and square. The rules remain the same. They are losing by the rules is the way it comes. And if they are cheating in order to get this stuff to win, the cheating isn't worth it. Well, in this case, those who have been cheating and gaming and playing the system have ended up coming out ahead. It's nice to see the Supreme Court is looking at things and saying, we are going to stop our own authority because we have our guys in the judiciary who are taking it too far. Yeah, prove me wrong.